Getting the media working. Professor Benjamin, do we have you in Texas over there?
I don't know if you can see me, but I can hear you.
Okay, great. We can see you. So I'm gonna get started and introduce our moderator and our panelists, and then we'll get started. Okay. I'm going to get started by introducing our forest panel, and
Can you turn up the sound, the audio?
okay, we're going to get started with our forest panel. Professor Benjamin, can you hear us?
Yes, I can.
Okay, wonderful. Our forest panel is going to be moderated by Lydia Olander. Lydia is a Senior Associate Director for Ecosystem Services for the Nicholas Institute. She's worked on a range of issues for the Institute, including national energy, transportation policy, and their linkages with climate change and climate policy, oil and energy security, clarifying new science relevant to the climate change policy for decision makers, water issues for North Carolina. She's currently focused on developing the Institute's expanding initiative on ecosystem services. Hopefully we've got the media problems resolved at this point. Okay. Well, if you'll bear with us, we have a professor from the University of Texas video conferencing in, so this is why we're having some media issues. But we'd like to bring up Lydia Olander now to begin our forest panel, if we can, hopefully we can.
Thank you very much for organizing this really interesting day of discussion. I think this is a great topic, and so far it's been a fascinating conversation. So I'm going to start giving a couple minutes overview, and then introduce our speakers, and we'll follow pretty much the same routine that the first session did in terms of approach, and I think you're going to be keeping time over here. Okay. So basically, international efforts to include deforestation in future climate agreements has moved forward very rapidly since its reintroduction into the negotiations in 2005. The U.S. Congress has indicated strong support for including forests, and even the European Union, who was originally strongly opposed, is working towards including forests. So this is a very kind of fast-moving discussion on a new approach for dealing with deforestation globally. And just want a moment while talk about why saving tropical forests is so important. It's extremely significant for climate. It's 15 to 20% of emissions come from forests, deforestation. It's a cost-effective approach. It brings multiple benefits, biodiversity and others. And they are rapidly disappearing, so this opportunity to address forests will be gone if we don't do it soon. But it's extremely challenging to implement. It is, of course, attached to all the challenges we discussed in the first panel, as linking it to a climate program has all those same issues. But in addition, it means countering global drivers, demand for food and timber, and without reducing supplies of these needed resources. And so come questions about how far can we go with intensification of agriculture and improved forest management. And then tying it more tightly to the questions of property here, it'll also require strong institutions and governance and clarified property rights where they don't currently exist. So this panel has been tasked with discussing these issues around property rights and looking at, can property regimes allocate the forest carbon resources efficiently through private property, group property, or government control? And how will the establishment of property regimes around forest carbon affect forest communities, many of whom have no formal property rights? So with that, I will introduce our speakers. So I think we will be starting with Antonio Benjamin from the University of Texas. Antonio Benjamin teaches comparative law and biodiversity law at the University of Texas. In 2006, he was nominated and sworn in as a justice of the Supreme Court of Brazil. He's also the founder of the Brazilian NGO Institute. He was responsible for the consumer and environmental litigation and drafted the Brazilian Consumer Protection Code, the Competition Act, and the Crimes Against the Environment Act. So with that, I would like to have Antonio Benjamin give his presentation, and I'll introduce the other speakers before they start their sessions.
Good morning. I wonder if everybody can hear me.
Yes.
Is the audio okay?
Somebody through the microphone.
Yeah.
Yes.
It's working great.
Oh, thank you. Well, first of all, my apologies for not being able to be at Duke this morning. This is a very interesting colloquium, and I wish I were present, not just to bring in my thoughts, but also to listen to the other panels, especially the one on water. I sent some slides, but I guess I was informed here by our technical folks that I cannot run them from here. So I will basically just go over what I would like you to see on those slides. The topic of this colloquium, connecting climate change to both water issues and forest issues, is most appropriate. I will start with an overview of legislative models to protect forests. And my focus here will not be at the international level, but mainly at domestic arena, since most of the countries that have large areas of tropical forest have legislated in terms of protecting, respect to protecting their own forest. And just to give you an idea of the importance of domestic legislation to protect forest, my country, Brazil, has 70% of Brazilian emissions, CO2 emissions, come from deforestation. And my one of the arguments that I will, the propositions that I will try to convey here today is that in addition to any international regime that we want to put in place for linking climate change and the protection of forests, we have to not just to enhance whatever legislative models that we have at national and state level, but also to enhance the way we implement those laws that are in place and quite often are just law in the books. Next, I will briefly discuss the international legal context that I'm sure will be further explored by the other panelists in this, with whom I share the discussion of this topic. Then I'll move to the domestic legal context that's really the focus of my presentation, and I will analyze the constitutional protection of forests. This is an area that in the U.S. does not have received much attention for obvious reason. The U.S. Constitution, the federal Constitution, does not protect directly the environment, let alone make any reference to the protection of forests. But this is not the case of other countries. In fact, many countries do not only protect the environment from a holistic perspective, but also make express reference to the protection of forests in general, but also sometimes specific forest biomes as it is the case of several constitutions in Latin America and Africa. Then I will discuss the statutory protection and models, apply those models, legislative models to the case of Brazil, particularly taking into account the fact, as I mentioned, that in Brazil, around 70% of our CO2 emissions come from deforestation. So in order to reduce those CO2 emissions, we have to address the issue of the implementation of the Forest Code and other laws that we have in place, without, of course, taking into account our international responsibilities that under the Climate Change Convention and the Kyoto Protocol and whatever comes after 2012. And I will conclude with some observations and prospects that, in my view, will frame this debate in the next years. Well, the first slide that I had, and you can't see, is just a map of world forests. And my intention here was just to use this as a factual basis for the challenge that we face in protecting especially tropical forests. So if the world, my point here, my argument here is that if the world really wanted to protect tropical forests, they are concentrated in a small number of countries. And so the challenge would not be one that would address the whole world, but an emphasis on 8-10 countries would cover over 70-80% of tropical forests in the world, including the Amazon rain basin, the Congo basin, and of course southeast forests that are as endangered as, or perhaps even more, than the Amazon rainforest. In terms of legislative models, and we are lawyers, and this is a law review that organized this colloquium, we need to understand the different models, legislative models that are possible in terms at the international level and domestically in terms of protecting forests. There are basically three main models, and other submodels that I won't be discussing here. First, traditionally we have protected forests on taking a species approach. This is found pretty much everywhere in the world, from common law to civil law countries, Africa, Latin America, Asia, Europe, in the United States. For example, in the US, you have the Endangered Species Act that is originally, at least, species-oriented, although the ecosystem approach has been being emphasized more recently. Still, in terms of protection of species, we have regulation of commerce and use. And at the international level, CITES, the Convention on International Trade on Endangered Species, is one example of the regulation of commerce. And the regulation of use, many countries in either their forest codes or forest legislation, but also in other environmental statutes, have regulated the use of forests. Sometimes not to protect forests per se, but to protect, for example, watershed and water in general. The second main legislative model is one that is area-based, what we could call area-based protection. And here the purpose is not to protect specific species that we might identify as being endangered, and that might be too late, but to protect whole areas. And the U.S. is a pioneer, as you all know, in this approach, starting at the federal level with Yellowstone, still in the late 19th century. And nowadays, most countries in the world do have a system of protected areas in place. The categories vary from country to country. Sometimes we call them by the same name, but the type of regulation of use is not the same. So a national park is not the same, or not always the same, in the US and in Australia or Brazil, for example. Area-based protection is much more efficient because we are protecting habitat and sometimes protecting habitat in a massive way, taking into consideration an ecosystem approach or even a whole biome, as there are examples of protected areas in several countries of this time. Finally, we have the ecosystem or an ecosystem legislative model. This is much more complicated because at least in terms of specific and concrete protection, not broad protection as some constitutions have done, for example, protecting a whole biome in general terms, but coming up with legislative measures and on the ground that would reflect this ecosystem approach to the protection of forests. And one of the problems that we face, especially in federal countries, is the artificial separation or division of ecosystems and biome as a consequence of state or administrative borders. This creates a huge amount of difficulties, but also problems in the implementation process, including judicial review. At the international level, and as I said, I won't be debating or discussing this in detail. I'm confident that my other colleagues will do that. The protection of forests has deserved the international attention much before the so-called environmental era. Stockholm, for example, in 1972, that is usually used as a starting point for pretty much everything that we do nowadays in terms of the protection of the environment. But it doesn't mention forests per se. It mentions flora, which is, in my view, much more appropriate. We didn't advance much at the international level in 1992 in the Rio Conference, since we what was presented in Rio in terms of forest protection was watered down, and unfortunately we were not able to approve or open to signature a forest convention as it was originally proposed. Agenda 21 does address forests specifically in Chapter 11, and there are a number of more recent efforts that I will not discuss here. And frankly, being as polite as possible, those efforts have taken us nowhere in terms of coming up with a strong and enforceable international agreement to protect forests. Let's now move to the area that I would really like to bring to the debate, which is the role that domestic legislation can play in protecting forests, and in countries like mine and Indonesia, in making it possible for those countries to reduce enormously their contribution to greenhouse gas emissions. Let me start again with the objectives of domestic legislation. As I mentioned previously, countries have enacted legislation to protect forests. They started doing this since the 19th century. But the main objective was not the protection of forests per se. It was not the protection of the environment. It was quite often the so-called optimum use of timber and later on erosion control. That's, for example, the case of the Brazilian Forest Code that was enacted first in 1934 and then in 1965. The present objectives of forest legislation are much wider, and we have we identified multiple functions of forest: economic, social, ecological, and of course, more and more an emphasis on ecological functions. Several countries have expressly protected forests in their constitutions. That's the case of several Latin American countries and African nations, and we cannot just say that those constitutional provisions are law in the books, that they don't play an important impact, especially in judicial construction of statutes that also protect forests. Let me, in the last 5 minutes that I have, move to the Brazilian situation. And my concern here is that we can publicize this fact that if Brazil were to really implement its domestic legislation that protects forests, we will be able to reduce a great amount of our CO2 emissions, as I have alluded before. And there are two quite unique and interesting legal tools that the Brazilian legal system has and that we don't find anywhere in the world. And I would like to mention both of them here briefly. The first one is known by the acronym, and Americans love acronyms, and we Brazilians are learning with them, is the APP. In Portuguese means permanent preservation areas. The Forest Code requires that those areas that are in riverbanks, top of mountains, and areas with an inclination of over 45 degrees, they are kept untouched. So no direct economic use. And when you transplant this system of APP to the Amazon with large flooded areas, one has to realize the importance of this in order to protect not just water, not just to protect wetlands, but also to protect large pieces of forest. The second one is even more unique, and only Paraguay in a recent or a more recent piece of legislation embrace it, following the example of Brazil. It's a very controversial so-called legal reserve. And that's the area in which my court, the High Court of Brazil, has in the past 5 years played a major role in clarifying doubts and construction problems that we had and still have in respect to this technique. It basically states that every single property in the Amazon biome can use only 20% of or can clear only 20% of the forest that is found in that property. It has to protect 80%. It used to be 50%, and this was raised to 80% in a major amendment of the Forest Code that happened in the 90s. In other parts of the country, this is at least 20%. So in the Atlantic forest, for example, it's not 80%, but I'm sorry, it's not 80%, but 20%. And I went with some case law from my court. What were the main issues that were before us? I will be able to briefly discuss two of them, and a third one I will just mention because we are still in the process of deciding that particular issue. The first issue before us was whether those two duties that that the Forest Code apply to landowners would be required from landowners that have purchased the property after the requirement was put in place. The two duties are, first, a duty to inscribe the forest reserve, legal reserve, on the title register, and second, a duty to restore whatever percentage that is necessary in order to comply with the now 80% legal reserve in the Amazon biome. And my court has decided that this duty applies to any property because it attaches itself to the title, and it's not a personal obligation, but what we call a real obligation, meaning an obligation that is attached to the thing itself. The second issue is whether what type of liability is, in terms of restoration is applicable to what type of regime of liability in case that the forest is destroyed by third parties, for example, by fires, or could be an act of God, or by peasants, the landless movement, for example. And my court has held that here we have strict liability, and the landowner is responsible for the restoration of the forest. Finally, the issue that I said it's still unresolved, and we'll visit this issue this year, is whether those landowners in the Amazon that have cleared 50% of the forest legally with a permit under the previous regime that was changed in the 90s, whether the new regime would apply to them. This is a much more complicated issue, and I can only mention it to you, but I cannot discuss the details. In conclusion, I don't mean to be pessimistic in terms of the role of law here, but we have to realize that of the many reasons for the survival of tropical forest as we still have them nowadays, we cannot include law as or recognizing law a main role. Basically, the forests are still there for three non-legal reasons. First, inaccessibility, and so here the whole need to work on transportation, forest protection, road building, and climate change. lack of roads, and low population pressure. Usually those large areas of forest are in parts of the country that have a very small population, and the population pressure as a consequence is not as high. But still, law can play, it's my view, can play an important role, and it has played, at least in my country, in the last 15 years. But law alone, or laws alone, do not mean much. We need first the rule of law, and this is missing in many parts of the world, and we need good enforcement. So those are my preliminary comments, and I'll be delighted to respond to any questions that you have.
Thank you very much for your comments. We were planning to move through the other panelists and then take questions after that. So we're going to move ahead, and I'm going to introduce Michael Wara, who's professor and research fellow at the program in Energy and Sustainable Development in Stanford's Freeman Spogli Institute for International Studies. He joined Stanford in 2007 as a research fellow and had a former life as a geochemist and climate scientist. He is an expert in environmental law and policy whose research focuses on climate policy and regulation, looking at the performance of the emerging global market for greenhouse gases and mechanisms for reducing emissions, especially in developing countries. So, Michael, turn it over to you.
Thanks. I'm a little bit, I'm honored to be here, and also a little bit intimidated because I think there are many experts, people who know perhaps more about forests. And
I can't hear you.
Can the audience, can you hear me now? No, not a good sign. Well, I was hopefully, yeah? We're on the air in Texas. Great. Okay. I was just saying that I'm also a little bit intimidated to be here because I think there are many people, in particular at the Nicholas School, who know much more about forests perhaps than I do. And so I'm going to try to bring to bear some of my expertise in the track record and performance of other types of emissions trading to bear on the question of developing a system to reduce emissions from deforestation and degradation, RED as it's called, in future climate agreement. And at the outset, I think it's important to recognize that our other major experiment in implementing emissions trading in developing countries, the clean development mechanism. If there's one thing that many people who study this would say about it, is that unintended consequences are rampant, that we need to think ahead of time about the indirect effects, the unexpected outcomes, or try to do that from the design and implementation of these extremely complex legal and market mechanisms. So what has the CDM taught us about the prerequisites for bringing to bear large amounts of carbon finance to emissions reductions in the developing world, and what does that imply? What does that imply for forests? Project risk in the CDM has been a key determinant for success. When you see projects that go, projects that work, projects that supply sources of funding, they tend to be low risk. In this context, in the forest context, I think that the key risk there are two risks that many people perceive. One is permanence, which I won't address, the idea that perhaps a carbon offset or a carbon credit that's generated from a forestry project might go up in smoke, quite literally. The other one, though, that I will address is the need for secure property rights. The CDM works in part because the property rights regime that motivates it is secure enough to guarantee investment, significant investment in projects that involve the certified non-existence of odorless, colorless gases. Is that? Oh, okay. I think the issue of secure property rights bears very differently in the forest context than it does in the clean development mechanism, in the sense that RED is not just another carbon offset, in the sense that it implicates land use and land tenure rights, and especially in countries where these rights are not well defined, where there are overlapping claims to these rights, and where the constituencies likely to be least able to defend these rights are indigenous people and people who traditionally lack access to the legal and economic resources that those bringing carbon finance to bear are likely to have in abundance. A key question about implementation of any RED program at the international scale is where to set the baseline. There's a general preference amongst those who think about the problems that have arisen under the clean development mechanism to set the baseline and the problems that emerge in implementation of forestry offset projects to set baselines for deforestation at the national level. This solves, at least substantially, the leakage problems. That is, the issue that a forestry project implemented in one spot creates incentives to remove forest through the markets for timber and land resources in another spot. The problem that I see that creating, and I think I'm not the only person, is how to translate a governmental baseline, a situation where, in essence, the government receives and is responsible for producing the benefits and receives the financial resources produced by emissions reductions. How to translate that down to the level of local economies and local constituencies that have, at best, contested claim to the forests in which they live and make a livelihood, especially in countries where governance is a significant issue, especially in the timber industry. It's worth noting that in many of the countries that it was correctly pointed out by the previous speaker, that matter from the tropical deforestation perspective, regulation of forestry activities is at best poor and at times non-existent. A wonderful example of this is that if you compare the amount of licensed cutting of timber in Vietnam to timber exports from Vietnam, the ratio is about 4 to 1. That is, for every tree that's cut down legally in Vietnam, 4 are exported. And that suggests that that country in particular, it's just one, but that country in particular has significant rule of law problems when it comes to regulating its forests. Problems that aren't necessarily going to be made better by the addition of lots of money from international sources. I would suggest that the problems that have been created by the CDM, mainly the problem of payment not resulting in changes in behavior that lead to emissions reductions, are fairly innocuous in comparison with the problems that are potentially created by a RED scheme, in the sense that we may have, for the first time really in the climate policy world, significant human rights implications to the functioning of a carbon market. In thinking about this, I think it's worth reflecting on the fact that we've learned about the problems with the CDM from its functioning, not from prior experimentation. Perhaps we should have read David's work earlier and we would have known that there were problems with offsets. Maybe folks negotiating did, but recognized that they had to craft international agreement to engage developing countries, and so hoped that things would turn out better. What's good about the RED process so far is the commitment made at Bali to do capacity development and experimentation ahead of international agreement, to essentially try to learn lessons about likely unintended consequences before we adopt a program in the form of international law that will be difficult to change. I think it's worth looking at how that experimentation is going now to see to what extent these concerns about human rights, about indigenous peoples, about the formalization of what are currently extremely informal property rights regimes is likely to portend. And I would argue that the picture doesn't look very good so far. A recent study of the World Bank, so the World Bank set up a forest carbon partnership facility as a part of its carbon finance unit, a carbon finance unit which has been extremely influential in the formation of many of the institutions that really motivate and drive carbon markets at the international level. The World Bank solicited project idea notes on reduced emissions through deforestation and degradation from a number of countries, and they have there 25 so far. An examination of them by a recent examination by an NGO in the lead up to Poznan suggested that these PINs contained little or no discussion of land tenure rights, a near total failure to address human rights issues, no requirements for prior informed consent on the part of communities that were engaged in using the forest for their livelihood, and in many respects, no clear plan to address forest governance issues. I think the problem is that the key institution for developing carbon markets and carbon market institutions, which historically has been the World Bank. I mean, there are wonderful empirical studies of the clean development mechanism that show that the odds of a new methodology for a carbon offset project being approved are significantly higher when the World Bank is the proponent of that methodology, whether it has good aspects or bad. But the key institution for developing carbon finance internationally is also an institution which historically and perhaps culturally has had a lot of trouble in dealing with issues of indigenous peoples and their rights to use of land. So, and I think you can point to the experience of the World Bank with dams as one example of that. So, in conclusion, I don't want to say that RED doesn't hold tremendous promise. 17% or so of emissions, it's hard to pin that number down. It's remarkable that the spread when you read these documents about what percentage of emissions actually comes from forests. But let's take 17% of emissions come from forests. There are clearly opportunities for low abatement costs there, and we shouldn't leave those emissions on the table. As a native of my state.
No, I cannot hear you.
Well, as Mary Nichols often likes to say in the context of our AB 32 implementation in California, leave no ton behind. And I think she's got it right. We can't afford to leave these low-cost tons behind. At the same time, I think that we should be extremely concerned and careful as we move forward with thinking about possible institutional design for RED implementation, that we not ignore the very significant human rights implications of what we're doing and the fact that adding lots of money has to a situation of substantial poverty and poor governance has the potential to transform the facts on the ground in ways that might be great for climate, but not always so positive for the people that live in these countries. So you're up, Jedediah.
Almost.
Thank you, Michael. So now I'd like to introduce Jedediah Purdy, who's both with Yale Law School as well as the Duke Law School. He graduated from Harvard College and got his JD from the Yale Law School. He teaches in environmental property and constitutional law and writes about the history and theory of property law, the development and prospects of American political culture, and the legal and cultural challenges of climate change. And he has previous experience clerking for the Honorable Pierre N. Laval in the Second U.S. Circuit Court of Appeals, so some on-the-ground practical experience as well. So, with that,
Thank you. Thanks to Carla and Rachel for bringing me down. It's really great to be back at Duke and back in North Carolina. They've asked me to keep my comments under 10 minutes, and I'll try to do that. So I'm going to anchor my discussion in the history of forest preservation in the United States and the transformation between the early 19th century, when vast tracts of forests were in the hands of the federal government, and it was almost an axiom of American politics that forests were for cutting, for rapid cutting, and for disbursement to private individuals and corporations who would cut them quickly and efficiently. To the end of the 19th and early 20th century, when the process was well underway, that put vast forests into permanent federal ownership and management where they remain today, with mixed results, but still a signal event in public forest management. So 4 things had to change for this to happen. An idea of the scientific character of the problems that implicated forest management, an idea of the purpose and functions of government, an idea about the scale and scope of political community, both who it was in your polity whose interests had some sort of bearing on your legitimate decisions, and also, more concretely, the role of the federal government versus local and state governments and private resource managers. And finally, there was a change in the value ascribed to the natural world and forests in particular. A change in the larger culture, but which translated specifically into changes in the public, political, and legal culture. I think this transformation is worth looking at because it's a starting point for talking about a third piece of our discussion today. In talking about climate change, we've focused on issues of optimal institutional design and politics in the sense of the politics of states, the strategic relations of national governments. The third part that I want to bring in here is political culture, domestic and transnational, that creates the political will for states to commit to economic sacrifices, sacrifices of convenience, the political cost of transitions, and to the cost of bribing or subsidizing other states in undertaking those. I think if we aren't attentive to the creation of the political will that makes the politics of states viable, that ultimately drives it, then we're going to be at risk of bootstrapping in our discussion of politics. So what had to change? Forests were for cutting at the beginning of the 19th century. Simply put, because of an idea of the character of the American political community, which focused on the idea that it was a society of equality among white men, at least, and that the form of the equality was equality of opportunity and the chance to make something of yourself, and that having equal standing in a political community of that kind included having the power to go out and claim a share of the wealth the federal government held in trust for disbursement to anyone who could do something productive with it. And in fact, the term public domain, which we now use to describe that which is permanently set aside in the interests of the public, was then used to describe something rather the opposite, something that was available for the private expropriation of you to go out and turn into your private property by improving it. So at the beginning of federal forest reservations, it was actually complained that the federal government was removing forests from the public domain by putting them in permanent federal management. What changed? Because this idea is in some ways the reverse of our sense of how forest management works. One, the beginnings of ecological science brought the recognition of significant spillover effects from deforestation, especially in erosion and the annual variation of stream flows downstream from headwater forests. This produced and legitimated and brought to focus political constituencies in the form of downstream irrigators and downstream municipalities who were very early and very strong advocates of the reservation and permanent management of federal forests. This presented a management problem which both became a new task for government and interacted with a larger change in political culture among reformists at the latter decades of the 19th century, in which a whole set of problems were coming to be seen as increasingly like the problem of forest management. Complex issues of interdependent systems in which the arrival at good or bad equilibria had to do very much with intelligent regulation. The rise of public health and labor market regulation as major concerns of public policy are, along with forestry management, signal developments in this change. Third, the federal government came to, and especially the executive branch in the federal government, came in much political conversation around this new set of complex interdependent problems to be seen as the portion of government that could operate uniquely on behalf of the interest of the whole society rather than some self-interested and externality-producing potentially destructive subset or special interest. And this political idea coincided very nicely with the fact that the federal government had a lot of forests already in its hands, which it could now flip its policy from dispersing to private holders to retaining in what was meant to be the long-term public ecological interest. Fourth, a new idea developed of what forests were good for that went beyond the simple instrumental economic value of getting timber off and also went beyond the somewhat more complex externalities managing concerns of federal retention and expert management. They came to be associated with the civic ideal of creating a permanent common public space where people could come together across classes and religious divisions and develop a common idea of themselves as Americans. They came also to be associated through the efforts of social movements like the Sierra Club and the political language that they contributed to the larger political culture, with a new idea that in certain kinds of wild places, you could have unique aesthetic and spiritual experiences, encounter kinds of beauty and kinds of enlightenment that you couldn't meet elsewhere. So all four of these changes were part and parcel of the U.S. reversal from forest clearing to forest preservation and forest management. I wanted to say, but I'll instead hold it for the discussion session, a few things about what, if anything, we can learn from this change about the prospects for the politics of global climate protection, which is the ultimate quarry to which global forest preservation is instrumental. But let me just end here having, I hope, set out a little of the material that we can work with in trying to think about the political culture dimension of this issue.
So thank you very much for those interesting, thought-provoking presentations. Because Professor Benjamin has to leave us at 12:05, we thought we might start by opening up for questions that might be particular to his presentation. And so I'd like to open that up, and then we'll come back to a more general discussion up front after that. So if there's specific questions for Professor Benjamin, we'd like to start with those. Yeah, and please introduce yourself.
David Russo, and I'm with the Duke Journal of Comparative International Law.
Okay, so I need to repeat everything?
We'll just ask.
Oh, can you hear the questions?
No, I can't hear well. Is it possible for the participant to ask the question from where you are?
Yes. Are you able to hear me?
Do you want to come down?
Oh,
I'm
yes.
sorry.
Why don't you use this?
He can hear you.
He
can hear you. Just speak loud.
I mean.
The sound of the forest.
Try again.
Now there's no sound. It's on their end, not ours. There's something wrong with the sound on their end. I think.
Oh, no, it has come in.
Professor Benjamin, this, I mean this in a very serious way. I was very curious when you said that an important non-legal factor was the inaccessibility and lack of road structure, naturally that would allow things to be, deforested. And this would probably be a very, unlikely political debate in the United States right now, but quite possibly in other countries, including your own, that there would be some concept that we intentionally would want to, for lack of a better term, isolate some areas. Again, it might not be very likely in the United States, but conceivably, would that be something that we should intentionally try to do, that in addition to legally protecting and isolating things, to physically say that we would wish that these places have less infrastructure, period?
Well, thank you very much for your question. The idea is not to isolate people in communities, is to use the right type of connection between the more developed parts of the country and those remote areas. For example, in the Amazon, we are not talking about just forgetting that those people are Brazilians and they have their own needs. But for example, instead of paving a highway, why not building a railroad? And this has been advocated by the governors of the Amazon region themselves. As you know, just look at any map of the Amazon and also of tropical forests in Africa. Wherever you see a road built and specially paved, the deforestation increased exponentially. So it's just we need to find the right balance between giving a good standard of living to those remote communities that have been linked and still are mainly by riverboats, and not opening remote areas of the country that are completely inaccessible to timber production or grain production or even cattle ranching under the excuse that we need to connect and those communities and give a decent standard of living to all of them.
Thank you. Any further questions? Benjamin? Annie? Do you want to?
Professor, I'd be very interested in your comments on President Lula's.
Were you able to hear that?
No, unfortunately not.
Okay. It was a question regarding. She was interested to hear your thoughts on President Lula's recent initiative. Did you hear that?
Yes.
Okay.
I'm thinking about what to say.
Okay.
Well, I have been a judge for the past in the High Court of Brazil for the past 2 years and a half, so I probably won't say exactly what, or especially the way I would say, as if you had asked this question about any president before I took this new position. What I can say is that deforestation is still massive in my country, and we have invested on enforcement and compliance, but there is still a long way to go. And I think this is recognized by the executive branch as well. And definitely it is recognized by the Brazilian judiciary, both the federal judiciary and state courts. There is a long way to go.
Thank you for that. So one more question, I think.
Professor Benjamin, Rachel Muchmore, DJCIL Symposium editor. I was wondering if you could speak a little bit to Professor Purdy's point about, I don't know if you heard, but he talked about the cultural imaginary and the way that how we perceive the forest to be an important part of deciding how we can go about implementing protections against deforestation. And I wondered if there were any efforts underway in Brazil that speak to the cultural imaginary or how people perceive forests in Brazil.
Well, thanks for the question, and it also gives me the opportunity to say how much I appreciate your talk. Because as he was describing the evolution, you are referring to the last speaker, right? Yeah. So as he was referring to the evolution of U.S. forest policy, I could see parallels in the way the same process occurred in my country. We have to remember that in the Western Hemisphere, for the colonizers, the forests were as they would call in Latin, terra incognita. In other words, a place that we should be afraid of. Forests were where the beasts, wildlife, lived. Forests occupied land that we would, if they were not there, use for production of food and for other goods that were in high demand in the colony and in the metropolis. So this type of cultural mindset is still very present in my country. Don't think that because we have such a progressive and quite, I would say, from a legal perspective, spectacular forest code, that forests in the Amazon or even in the most developed parts of the country are seen the way we in this panel and in the journal see them. Forests are, and especially in respect to the Amazon, those that live there, first of all, they don't understand why we are concerned with deforestation. When you fly over the Amazon or the Congo Basin or even in Indonesia and Southeast Asia, what you see is a green carpet of forests for hundreds and hundreds of miles. This they cannot grasp, they cannot understand easily. Second, they see in the Amazon especially, they see all those laws that are being passed, and I have co-drafted a number of them, as a sort of domestic green imperialism, but also there are all sorts of conspiracy theories that we are agents of countries like the United States, the European Union, as if the United States were concerned at all with tropical forests in the last, especially in the last 8 years, but even in previous administrations. So the role of law here is one not just that put in legislative terms what is already part of the cultural mindset, but it's one of helping to transform this mindset, making customs, even customs that were considered completely normal, illegal. And then there will be a gap in implementation until this mindset is slowly transformed. So we don't need, we don't have to be, we should not be too tough on the failures of the legal regimes that have been put in place in the next 20, 30 years, because that's a very short period of time to transform a collective mindset, but also the same mindset that is part of those that make up the judiciary, the police force, even environmental protection agencies.
Thank you. I was wondering if you would like to respond to that or talk a little bit more about what you were saying about how the U.S. experience, the American experience relates.
Maybe very briefly. So that's extremely interesting. One thing that's striking about it, if I understood Professor Benjamin's last point accurately, is that there's a thought that a change in cultural attitudes toward forests can begin in legal change, begin in a new national code, even if that's quite divergent from people's everyday, popular, existing sense of their entitlements, and that over time the kind of operative consciousness and practices will follow the legal change. That's a mode of change that I would say in the US has probably been in relative decline in the amount of faith that people wanted to put into it in recent decades, relative to maybe a high water mark of 40 years ago, or even a little longer than that. Even at the time of the passage of the major environmental statutes of the early 1970s, though, there was enormous confidence in Congress and among elite opinion makers in the viability of change that began at the top and began in formal legal codes. We may see another round of experiments in the interaction between formal legal decision-making and the broader kind of ferment of cultural debate in climate stuff.
Can I add just something to what I said? You see, this type of both constitutional and statutory design is pervasive in Latin America. I understand that there are all sorts of difficulties with such an approach, but that's the way it has been, especially in areas that in which we do not have much time to wait until society as a whole come up with the changes that we think are most appropriate. This happened with slavery in my country. Slavery was abolished in 1888, not because the landowners and the elite of the economic elite of the country thought that that was the right thing to do at that time. This happened with a number of other social issues. And frankly, in the area of forest protection, and especially tropical forests, we don't have much time. And we have to try as much as possible, and I am guilty, I'm confessing, I'm guilty of this, if this is a sin, of pushing Congress to go much beyond, my Congress, to go much beyond what is the cultural mindset of that moment, for example, in the Amazon. And there are, of course, all sorts of reactions to the implementation of law, but my experience in this area, I've been working with forest issues for the past 27 years, is that there is an accommodation process, and later on, what is legal becomes what's sociable, from a social point of view, desirable. So I'm confessing that I'm guilty of such a sin.
Something very quickly. That was a terrific, informative, and gracious response. I just want to say I didn't at all mean to say, here in America, we know that law stuff doesn't work. Very much to the contrary. More of an observation that I think in the context of serious policy change around climate issues, we may need to start testing again capacities that we have recently lost faith in and neglected to maintain, which is the capacity actually to engage citizens in change that is in some ways in the first instance legal, and in which public debate and the legal instantiation of public political debate sort of takes the lead in a broader churn rather than wait for it to bubble up. So I think what you say is very helpful and very clarifying. Sometimes we're good at that, sometimes we're bad at that, or that is sometimes we're recalcitrant. We didn't take very well to the metric system, for example. And when they briefly tried to enforce the laws prohibiting mining on federal lands in California in 1848, everyone except the guy who issued the command to stop the miners dropped their guns and went out and started mining gold instead. So that was the end of the follow the law model for the gold fields. But sometimes it works well. I happen to think that our political culture at the moment is experiencing a revival of the possibility of politically led change, partly around the last election. And that may be momentum that we can draw on.
Well, there is one, just a final note, there is one aspect that we cannot forget in the forest protection debate, and also this is connected to climate change in general, is that deforestation, especially of tropical forests, is not an environmental issue of the type that we faced in the pollution control area. Nobody would deny that in the United States, or even in several less developed countries, that the rivers are in a much better, the quality of water in rivers is much better than it used to be in the 70s or the 80s. The quality of air. So in other words, those issues are reversible. I don't know of a single case of a massive deforestation anywhere in the world of tropical forest that has been reversed. Yeah. It's hard for Americans to understand this, because this is a country in which the percentage of land covered by forest has been increasing dramatically in the past 50 years. There are states that had no forest or almost no forest left, and nowadays 50% of the area of that state is covered by forest. But those are temperate forests.
Excuse me.
Try to bring back 100,000 hectares or 200,000 acres of pristine tropical forest with species that we have not even identified. So,
Professor Benjamin, I think they may cut you off shortly. So this is
of irreversibility and urgency is one that is we cannot be forgotten in the forest debate that we have nowadays. Thank you.
Yeah, I'm sorry. I think the technical folks are going to cut you off right now. So, well. Do you have any response to the last comments he was making, or should we move on to a new?
Well, I'd say one thing, actually, and this may be, I don't know, I think this exposes some of the tensions in the debate about REDD and what the proper purpose of it is that from a climate perspective, Professor Benjamin spoke very eloquently about the non-climate aspects of old-growth tropical rainforest, pristine tropical rainforest, that aren't preserved when it's cut down, but other forests regrow. They're not the same. Just as in the United States, we've had regrowth of forests, they are not the same as the forests that were cut when Europeans first came to this country, or that continue to be cut where I come from to some extent, if there's anything left. But from a climate perspective, it may not matter. And that is the carbon market will not care whether species are preserved. It will care whether carbon is stored. And so I think it's worth bearing in mind what it can and cannot accomplish in terms of biodiversity preservation.
So I wanted to announce this earlier, but it didn't seem appropriate. The organizers suggested that this conversation could go on till 12:30 if there's enough interest and interaction to do so, pushing lunch back a little bit. So I thought I'd tell you that we have a little bit more time to discuss beyond. So I thought I'd take this opportunity to ask a question. I'd been curious to know the thoughts of Michael in particular on this, but I think there'll be a broader conversation. From my experience thinking about the issue of forests and climate policy, there are very diverse opinions about how a REDD policy could affect local communities, ranging from the fairly positive, where we get improved local livelihoods, alleviating poverty, promoting sustainable development, improved forest governance, and better infrastructure because of the transparency that markets would bring. And then at the other side of the spectrum, you have more of the concerns that Michael was raising, where you have issues with property rights and you have communities losing rights to land where they live, and this causing potential, I think in your abstract you even suggested potentially violence resulting. And I think there's something different about the market approach, which is the potential of buyers to require certain things in the projects or policies that the credits that they might purchase. So there's some standards like the conservation and community and biodiversity standards out there that a lot of the early pilot projects are using, which are supposed to and supposedly take into account issues about community and biodiversity and not just carbon. And so I'm kind of curious about, how can we push things toward that more positive end of the spectrum? What kinds of things are possible when we think about bringing forests into a climate policy? So.
Well, it's a tricky problem because I think that governments are understandably reluctant to allow international institutions to determine their land use policies. But ultimately, in order to really guarantee the kinds of good outcomes that we'd like to see, I think something like that is going to be required, whether it's via a standards-based approach or some other. Let's see. I would argue that the CDM experience doesn't bode particularly well for that. And the one example of this is how sustainability is handled in the CDM. So the CDM is supposed to fund sustainable development in participating countries, in host countries. But very early on, the decision was made that what is or is not sustainable is up to the host country to decide, which makes sense from an international law perspective. The problem with it is that it has essentially meant that it doesn't mean much of anything in practice. Now, of course, you're right. Buyers can refuse to buy credits. But in a market that is that's supplied with largely fungible assets, credits. Even if, for instance, well-thinking European governments or the U.S. opt not to purchase the bad forest credits, it's likely that someone else will, because they'll trade at a discount, and they will still count as compliance assets in an international treaty. So maybe the solution is to build those standards into the treaty. I think that's going to be difficult to do because of countries that will be reluctant to commit ahead of time, not really knowing what they're getting into, or maybe knowing what they're getting into.
Well, Annie, I think I saw your hand first.
Specifically to that point, can you hear me?
Yeah.
This is where I think Professor Wiener's insight about the continuum of decision-making is really useful. If you have at one end on the continuum of decision-making the treaty-based approach where everything has to be done by consensus, you do run into the problem that countries, as Professor Benjamin pointed out, are very sensitive to paternalistic northerners coming in and telling them what they can and cannot do with their forests. And so countries are going to be unlikely to agree to international rules that contain detailed specifications for what does and does not constitute sustainable development. And we certainly learned that with the Clean Development Mechanism, where it was clear from the get-go that countries would not accept, that developing countries who wanted to participate in the Clean Development Mechanism would not accept an externally dictated set of standards for what constituted clean development. At the other end of the spectrum, as Professor Wiener described it, is the idea of a unitary, benevolent dictator or whatever, a single decision maker. But the middle area, where democratic decision-making processes that involve majority voting obtains, is one where we have important opportunities. We're now in a period of what I call ping pong, or what Professor Wiener calls a little bit more eloquently do-si-do, between domestic legislative initiatives like Congress enacting climate change legislation, like the EU doing its framework for climate, and the international arena. And so if you change your thinking about it, instead of thinking, are we going to be able to dictate standards to other countries, but instead start thinking of it in terms of, we're creating new markets here. And countries, as a matter of their national decision-making powers through legislative processes, have the ability to determine the conditions of market access for the carbon market they are creating. Then the United States, through the Congress, Europe through the Commission and Parliament, can say, if you would like to tender forest carbon currency for compliance in our countries, here are the attributes that forest carbon currency will have to have in order to be acceptable for compliance. And if you look at it in that respect, the big demandeurs of forest carbon currency are a handful of countries: the United States, the European Union, Australia, Japan, New Zealand, Canada. Who am I forgetting? Right now, those countries have the opportunity to set, through either by an association among themselves or through their national domestic legislative processes, the kinds of standards that you're talking about, which I think are needed.
Great. David?
Yeah, is this microphone working? Yeah, okay. Well, the question I had was, you're talking a lot about cultural factors being important in forest policy. In Brazil, they've had good laws on the books and great difficulty in enforcing them, and I assume that's true of a lot of places. And I guess the question is, the hypothesis of the value of including forest in the climate change credit markets has to be that money will contribute meaningfully to getting protection. There's something money can buy that will add value here. And I'm just wondering about your thoughts about the extent to which that might be true, and if so, how. Does buying credits, the process of getting money for doing forest protection, how does that money get used to advance it? I mean, it's not clear that if it's a problem of cultural transformation, the money can do this. I don't know if you can use money to keep peasants on land so they don't invade forests. How does the money do anything here?
So I guess I sort of see or meant to say something about the question a little bit backward from that. It strikes me that as long as you have reasonably effective implementation of property modeled rights, then you can probably, including monitoring, it doesn't seem that problematic for me that money can buy forest protection. But what I think is the question that cultural transformation goes into is who's going to sustain the political will to provide the money. That is, it's a question about setting political priorities that is the same form as the question of creating the political will to enter into a meaningful cap and trade system in the first place. Generally, to agree politically to make serious sacrifices of present convenience. So I think that's the register that I meant to be working on. So in that way, the analog to forests in the US experience is not so much forests in Brazil under an effective red analog as it is the global atmosphere and ecological integrity as viewed from the perspective of the polities that are committing to taking on the cost. Is that responsive?
I'm still not clear on how the money is used exactly.
I'm not either.
Yeah.
I don't know anything about that. Michael, I think
I don't think anybody's clear. I mean, that's the question, right? The question is how we translate international monetary flows into actions at the local level. That's
Yeah.
I
guess if I could.
No, go right ahead.
I guess I would just add the observation that we don't know what putting, say, $20 billion into the equation is going to do, but what we do know is that money is not there right now, and what's dictating land use in the tropics is money in agriculture, money in logging, and money in other types of extractive uses that are really the dominant source. And so money is clearly driving what's happening right now, and without any money to counter that, to keep the forest intact, I don't see how. I do see how strengthening the institutions, particularly with more money coming in, is absolutely necessary to get it done. But I don't think the cultural shift has enough to stop 13 million hectares per year being cleared from tropical forests.
Other questions from the audience? We have a couple minutes left.
Is part of the consideration a possibility of reservations or forest, preservations paying people as you said, to stay out of the forest and off the land, or is that running into too many of the problems that Annie, that Professor Petzonk mentioned about, who is going to be telling people to do this? I mean, can we really get countries to participate in international treaties, saying we're going to preserve a certain amount of our forests? I mean, I guess I'm asking, does the cultural imaginary have to come first before this money can be put to any use so that we have an idea that we need to preserve these forests, or how do either of you see that?
I think that for serious, sustained financial commitments to be made to any kind of policy that's easy to present as a foreign aid policy or an effort to avert a speculative set of future environmental harms, you need a form of political will that can combine people's sense of what's important and people's sense of how the world works. So it's not that it needs to be just about values, say, but that it does involve some shared picture of what you call a cultural imaginary, some shared picture of what's most important and how likely impending events bear on the priorities they're actually willing to act on. I think that you can regard some political stuff that's going on now that otherwise looks really anomalous and sort of random as efforts to generate that kind of political will. Like, what do you do with the fact that municipalities are nominally adopting the Kyoto standards? Hundreds of them around the country, over 700 last time I checked. Not often with a lot of noise. So most of you probably don't know that Durham is one of the towns that have announced their intent to try to meet Kyoto standards for carbon reduction, greenhouse gas emission reduction. This is either picture-perfect, futile, irrational behavior, or it's an attempt to engage in a form of political persuasion by trying to generate the idea that regardless of the presence or absence of current national leadership and effective international coordination, this is an imperative issue that people are willing to act on and expect to see others act on, with the aim of creating some sort of threshold effect or reaching a tipping point in the political culture in which this is a demand that has to be confronted. One example of what I think this politics looks like on the micro level.
I would tend to attack the hypo a little bit in the following sense. I think that for RED to be successful in the human rights context, we need to find a way of avoiding deforestation that is consistent with cultures on the ground in developing countries. And that does not mean depopulating the forest. It does mean preventing the kinds of activities I think Brian is referring to in terms of industrial logging, industrial scale activity in the forest. But finding what are in some sense culturally consistent ways of using the forest, I think is going to be a very important part of a successful program.
Are we out of time? One more? Okay. One more question? Prasad?
Yeah, I just worry with the discussion of RED, we're getting to a point where we are starting to get a sense that preserving forests is most important from a climate perspective, as opposed to from other. The climate benefit is what we should get. Everything else is great if we can get it. And it's actually the other way around. I mean, at current rates of deforestation, the climate impact from a greenhouse gas perspective, it is not that big. And I just wonder if the way we're approaching it, whether we're losing perspective on that score.
Well,
you know the science better than I do. I'll say I think it's always the tendency of political and academic conversation to seize on what's become salient and experiment with stuffing other things into the frame it presents, and that climate has sort of been on the other side of the ampersand with every thought experiment people have engaged in for the last few years, like climate and this, climate and that. Partly because there's a perception that there's sort of urgency and plasticity around the issue, and maybe you can get something done there. I don't know enough to say that I think it's a mistake, but I certainly see that it's not the only way to frame forest values. What do you think, Michael?
I would consider the interests not concerned about biodiversity in developed countries that are interested in RED. There is a broad perception that the clean development mechanism has not been a success. That being said, it is the main supply of cost control to cap and trade regimes in the developed world. So if we're going to have, and it's taken as an assumption, I think by many, that if we're going to have cap and trade in the developed world, we're going to have offsets. And they're probably going to have to be international offsets. So if CDM isn't going to be what we do, well, we better find some other kind of cost control coming from the developing world. And I think that forestry is perceived as a new alternative. Maybe that we could do better, hopefully that we could do better than the CDM in terms of its environmental credibility, also perhaps in terms of its impacts on the ground. But there's a real interest in it because of its potential impact on near-term compliance costs in the developed world. So it's not really motivated. It is partly motivated by climate, but it's also motivated by economic concerns here.
Well, thank you very much. It's been a great discussion. Thanks a lot.
Thank you to Lydia Olander, to Professor Benjamin for video conferencing in, to Professors Purdy and Wara for some very great food for thought. Thank you all for bearing with us with our technical difficulties. As far as food for food, we have lunch now in the Birdman Lounge, which if you're not familiar with the law school, you just go straight out this door, down the hallway that's in front of you, and to your right. And we will begin with our last panel, our water panel, at 1:30 in this room. So see you all there and have a wonderful lunch. Thank you again for bearing with us through our technical trial.